Good evening to everyone who's joining, and thanks for coming along to this session on the EU delegation to the UK's webpage, Facebook Live page. Sorry, it's a session with myself, Chris Ben. I'm an immigration lawyer with a firm called Seraphis, and the purpose of the session this evening is to provide information to EU citizens and family members who are living in the UK. And we cover things mainly to do with the EU settlement scheme, but other post-Brexit rights, and try to kind of give people information about what the living in the UK looks like in the post-Brexit world, because it can be confusing, as we'll talk about particularly in terms of travel rights and things like that. And so we aim to try to give people a good idea and make ourselves available to answer questions directly, and to hopefully provide you with some useful information. Anyone who's joined the session previously will know it's a pretty straightforward format. What we do is we spend about half an hour or so talking through some slide presentation which covers a particular topic. We try to pick the topics on what is relevant to people, what feedback we're receiving, and also sometimes it will be to do with policy updates from UK government, or as is the case this evening, we know we're coming up to a busy travel period, and so we want to identify travel as a topic to talk about in the coming weeks and months over Christmas. And so that's how we choose the discussion topic. And then after that, we have a question and answer session, which can be about the topic that we are covering, or it can be about anything else to do with the EU settlement scheme, to do with citizens' rights. And we'll obviously try to provide as much helpful information as possible. We tend to run no longer than an hour. We know time is precious, and it's an evening. People have been busy with their day, so we don't want to take up too much time. But we find an hour is usually a good amount of time to get through things and to answer questions. So feel free to use the comments section to ask any questions. My colleague Caroline is behind the scenes and will pick up the questions and send them over to me for when I have finished talking through our presentation. So that's the idea. We have, as I said, we've chosen to talk about travel this evening because of the time of year. It is very busy with travel. People are looking to leave the UK to go visit family, go see friends, go home for the Christmas period and the holidays, and also we might have families coming to see people in the UK, and so we want to talk about that because the situation in terms of your family and friends coming to visit you in the UK is very different this year than what it would have been last year, because of the introduction of what's called Electronic Travel Authorisation, and that's the first topic that we're going to cover. And one of the reasons we're going to focus on this is because we've had some feedback that people are still a little bit confused about how electronic travel authorization works, what it is, what's the purpose of it, what does it allow you to do, and why can it sometimes be a bit of a confusing thing for people to use effectively. So we want to talk about that, and then we'll also talk about people who live in the UK who have statuses and what to make sure you do to make sure that travel is as smooth as possible when you're traveling back to the UK. So why is electronic travel authorization so important? The reason is because up until it was introduced in April this year, European nationals did not need any prior permission to travel to the UK. The reason for that is because EU nationals visiting the UK are considered to be visa-free. And what that means is you do not need to apply for a visa to visit the UK, because that's the agreement between the UK and the EU. One of the Brexit agreements said we want smooth, free, essentially sort of free visiting travel between the UK and the EU. So EU nationals are considered to be visa-free nationals. However, whereas before April, that meant essentially you could travel to the UK border and then explain or that you were visiting, or you could come through the e-gates. Now, you would have to, if you're an EU citizen visiting the UK, you have to apply for something called an Electronic Travel Authorisation, ETA, as it's very often referred to. So what is an ETA? It's essentially it's an electronic permission. So it's like a permission to travel. It's not a visa, and I'll come back to why it's not a visa in a second. But the important thing is it's a permission that is checked at the point you intend to travel to the UK. So if you go, you book a flight from the EU to the UK. When you come to take your flight, the airline who you're flying with has to check with the Home Office that if you are an EU citizen, you don't have any other type of immigration permission, so you're assumed to be visiting the UK. So the airline has to check that you have been issued with an ETA, because that's a permission that you now require as an EU visitor to the UK. And it's a permission that adults and children require. It's not just for those who are over 18. Any EU visitor to the UK needs to hold an ETA, except, as I said, for those who already have some other kind of immigration permission. Usually that will be a visa, or it could be status under the EU settlement scheme, as I'll come back to. So ETA is for those EU citizens who were visiting the UK who do not hold an immigration permission to come into or to live in the UK. It costs £16 to apply for an ETA, and when it is successfully issued, as it is in almost all cases, the ETA lasts for 2 years, or it lasts until the end of the current passport that you're using, if your passport has less than 2 years validity on it. So if you have a passport that's expiring in a year, your ETA will be given for 1 year rather than 2 years, because it's linked to your passport that you're traveling with. And when you get a new passport, you need to apply for a new ETA to be attached to your new passport, and that one will be issued for 2 years, because most passports have 10 years of validity. So once you have got your ETA and it's attached to your passport, then you are able to visit the UK on multiple occasions within the validity of the ETA. So if it is a one for 2 years, then you can come to the UK using that same ETA for 2 years. But of course, when you're visiting the UK, the maximum time you can spend in the UK is 6 months. And so obviously you can't come to the UK for 2 years using an ETA, because you would go over the time allowed for the visiting permission, which says a maximum of 6 months. So what I mean by saying you can use it for multiple visits is that if you are coming to visit someone in the UK this Christmas, and then you might be coming to visit them in the summer, and then you might be coming to visit them in next Christmas, but it's all for like short periods of time, then that would all be within the validity of the ETA, and that would be okay, because you're never visiting for more than 6 months when you enter. So that's how the ETA works for multiple visits. And one of the reasons why we are looking to kind of emphasize this message about visiting is because some more recent reports that we've received have been about citizens who've got to the UK border and they've had an ETA issued to them, but then have faced a problem at the UK border for some reason. And there might be different reasons why this happens, but it usually will be tied to the fact that an ETA is for visiting the UK. So when you are visiting the UK and you have your ETA, it should all work relatively smoothly. But if your purpose of traveling to the UK is not for a visit, if it's for some other reason, if you're intending to work in the UK, or if you are you're going to become a student studying in the UK, then you actually will need a visa, because those are purposes that are not covered by the visiting rules. You can't work in the UK if you've entered as a visitor, and so you need a specific visa for that. So if your purpose, if you want to come and work for a UK company in the UK, then you will need, usually it's what's called a skilled worker visa. That's a sponsored visa to come and work here. Or if you're coming to study at university here, you'll need a student visa which covers international students. So that's the first thing to be aware of, and that can cause a problem. But even what may cause even a bigger issue based on sort of feedback we've received is what happens when you get to the UK border, because the ETA, as I started talking about, is the permission for the airline or the other carrier to let you travel to the UK border. But when you get to the UK border, whether you're permitted entry is governed by the rules, the visiting rules. So you may be going through an e-gate when you arrive here, and if you go through an e-gate as an EU citizen, which you're permitted to do, you're unlikely to have any questions because you just go through the electronic gate and you're given visiting permission when you go through the electronic gates. But if you are going through an immigration desk, if that's the entry at the UK border, then you may well speak to an immigration official, and they may well be asking you questions about the purpose of your stay in the UK. So they'll see that you have an ETA, but they still have to understand that your purpose of entry is within the visiting rules, because that's why you have your ETA. And so you may be asked about how long are you staying in the UK, who are you, is your purpose of visiting, is it to see family, is it to see friends, is it for tourist purposes? So the border officers are entitled to ask you those questions to establish that you are genuinely visiting the UK. And it's the cases where the officials think that someone isn't genuinely visiting the UK that they might deny them entry. And to be clear, that can happen even if you have been granted an ETA, because the ETA is not a visa, and it's not a visa to enter the UK. It's just the permission to travel to the UK border, and that's why it's really important to understand what this ETA is. So essentially, if the advice that we would give to people is if you've been granted an ETA and you're visiting the UK, we wouldn't anticipate someone having issues at the UK border. But it's just about being prepared to perhaps explain the purpose of your visit, the length of your stay. If you do have to speak to a border officer at the immigration desk, and things that are really, that can be helpful to show that you're visiting is when is your return travel? Is it booked? If it's not been booked yet, why isn't it being booked? Because obviously one-way travel into the UK is something that could create a suspicion, I guess, in a border officer about why you've come to the UK. Also, where are you staying? Are you staying with family, friends? Are you staying in booked accommodation? You can be asked to show that you have enough money to cover the cost of your trip to the UK, all things like that. So it's just about having just being prepared for possible questions that can arise at the UK border. But just to be clear, we're not sort of trying to make people overly concerned. It's because the majority of people with an ETA will be able to enter the UK for their visit, and there won't be any issues. It's just we have had some feedback from people, from organisations and stakeholders saying there have been instances where people with ETA are concerned and confused about why they didn't get granted entry, and that might be one of the reasons. So it's just important to think ahead of your travel to the UK. So the final thing just to say about ETA is what happens if you apply for one but you don't get granted, because this can happen. There are two reasons why you might not get an ETA if you've applied for one. The less common outcome is that you might get refused an ETA, and I'll come back to that in a second. But more likely it's about the application being rejected. And that happens if something goes wrong with the application. So it's not that you're being told you can't have an ETA, but something about the application process hasn't gone quite right. And it means that the application itself gets rejected. And that's why you haven't been able to get granted your ETA for travel. So an example would be if the digital photograph that's uploaded in the application process isn't one that's kind of compatible, or it's not a good enough photograph for the Home Office to be able to see clearly who you are, that might cause the application to be rejected. It's a sort of quite a common thing that can happen. In that situation, you take a better photograph and then you try and reapply, and hopefully that will resolve the issue. So usually with rejected applications, something to do with the process, and all being well, you can resolve it relatively easily and get your application confirmed and get your ETA issued. There are some situations where an ETA would be refused. This is a very, very small percentage of the overall numbers of ETAs that are granted, but it's important to be aware. And that is usually to do with the person being deemed to be unsuitable to be granted an ETA, because what the ETA is, as I say, it's permission to travel to the UK. So there are some people that the Home Office thinks are not suitable to travel to the UK, and they will not give them an ETA. So the obvious situation is if someone has criminal offences that reach a sufficient threshold, then the Home Office will say, well, you're not a suitable person to travel to the UK, so we will refuse you an ETA. So that's the one of the reason why someone would be refused an ETA. Now, what do you do if you've been refused an ETA for something like that? Your only option is to apply for a visit visa, and part of that process of applying for a visit visa is saying, well, I have, effectively, if you have a criminal conviction that's led to you being refused ETA, you would need to, in your visit visa application, explain why you should be granted a visit visa, and more scrutiny will be given to a visit visa application, because the person deciding the visit visa application can look at more information about your situation than can be seen in the ETA application. It might be the case that if you're refused ETA because of a criminal conviction, you will also be refused a visit visa because of a criminal conviction. So it's not to say that if you're refused ETA, you will definitely get a visit visa, but it's just to say that there's if you are refused an ETA because you're not deemed suitable, the option that you have to try to still travel to the UK is to apply for a visit visa. But if that situation applies to you, we would advise getting legal advice before applying for a visit visa, because it's likely that there are some serious issues that need to be addressed in an application for a visit visa. So it's a small, like I say, it's a very, very small fraction of cases fall into that category, but that just to make people aware that is one of that's how the sort of refusal decision and what to do about it works. So that's electronic travel authorization. There's obviously more to it that we could talk about. We've done whole sessions on them, but we're just trying to give an overview of travel information for people over this period. So we'll move now to talk about pre-settled and settled status holders, because obviously these are EU nationals or family members of EU nationals who have been given status under the EU settlement scheme, and the settlement scheme is for those who are living in the UK before Brexit took effect at the end of 2020. So you will have a status granted. Most people who were living in the UK by the end of 2020 do already have pre-settled or settled status. There are some people who might not yet have applied who could make a late application, but the majority of people, European nationals, family members who are living here by the end of 2020, have made their applications to the settlement scheme and have been granted a status, either pre-settled or settled status. So part of the rights that you have as someone who qualifies under the settlement scheme is that you are probably also someone who is protected by the withdrawal agreement between the UK and the EU, and the purpose of the withdrawal agreement is to is to make sure that your rights are protected as someone who has moved to the UK in free movement times but has been affected by the UK's exit from the EU. And that includes the right to travel freely between the UK and elsewhere, because the UK is your home. So because you have pre-settled or settled status, you will not need to apply for an electronic travel authorisation. You don't need one. It is not something that you will be asked to show to an airline or other carrier, because you have status under the EU settlement scheme. So that's the really important thing to bear in mind. Sometimes we hear about people with status under the settlement scheme also applying for an ETA as a sort of, I guess, a backup, but you shouldn't have to do that. And that's not the purpose of ETAs. You're not a category of person who requires an ETA, even though you could probably make an application and it would be probably approved. But that's not what you're supposed to do, because you hold pre-settled or settled status. But the important thing about your status is that it is linked to a travel document. You have an account with the Home Office. It's accessed via gov.uk, and your UK Visa and Immigration account, as it's called, UKVI account, often shortened to, is it shows your status under the settlement scheme. You see your picture, see which status you have, pre-settled or settled, and that is your proof of immigration status. And it's also effectively your proof that you do not need an electronic travel authorization. But this is the really important part of this, is that because when you applied to the settlement scheme, you used either a passport or an EU national ID card, and your account is linked to that document that you applied with. That's how the Home Office sets up the account, and when you come to log into your account, you will be asked for the reference number of the document you use. So if you apply to the settlement scheme with your EU passport, you use the reference number in your passport to access your UKVI account, and that's the first thing that you enter when you go to log in. So that's fine if you still have the same passport, but if you've changed passports, or if you have a national ID card and that's what you use to travel on more often than not, but you didn't use that national ID card to apply to the settlement scheme, what do you do? Because your account with the Home Office doesn't link to the document that you want to travel with. So this is why it's important to keep your UKVI account up to date, and that means adding in new travel documents when they come up. If you have a passport and a national ID card, and you sometimes travel on one, sometimes on the other, add them both to the account. Make sure that they're both registered, because when they're both registered, when your document you're traveling with is registered to your account, that when you come to book and check in with your airline or with the Eurostar, they will use that travel document, and that will link to the Home Office account, and the Home Office says to the airline or to Eurostar or to the ferry, yes, this person has got pre-settled or settled status, they are allowed to travel to the UK, i.e. they do not need an electronic travel authorization. So that's the importance of connecting the document you use for traveling to your UKVI account, because most of the issues with traveling will arise for someone with status under the settlement scheme is when their document isn't linked, because then the Home Office can't give the message to the airline that you have permission to travel, and then you have to prove to the airline, or the airline has to ring up the Home Office call center and find out if you have status under the scheme and that you have permission to travel. So it creates all these delays, and in travel situations, delays can be very difficult to manage, and you might not have enough time to resolve. So the key that we want to emphasize is to keep your UKVI account up to date with your new travel documents, and make sure that you do this before you travel wherever possible. If it's not possible to update your document before you travel, then if you can, keep hold of the document that is linked to your UKVI account, even if it's expired, and use it with your new travel document to travel, or if you've had to give back your old document, keep a copy of it, make a copy of it before you have to return it to the sort of consular authority to get the new travel document. So just try to keep a copy of it. If you can't update the account before you travel, you can now update the UKVI account if you're outside the UK in some situations, not every situation. But so if you happen to get a new passport when you're outside the UK, you can try to upload the new passport to your UKVI account even if you're not in the UK. It's quite likely over the coming weeks that you might get communication from the Home Office, who periodically will send information to EU settlement scheme holders, and one of the messages the Home Office is going to push with their upcoming communications is to reinforce this message of keep your UKVI account up to date, because it is really important. And that also includes with things like email addresses or telephone numbers, because that's how the Home Office communicates with people who hold status, by using the details that are in the account. So that needs to be updated. But really, the most important thing is to keep your account updated with new documents when you receive them. So that is the main piece of information about traveling when you have pre-settled and settled status. One thing we do also get asked about as a sort of connected issue with status under the settlement scheme is like, well, what happens if I want to spend periods outside the UK? Because not everyone will still be living in the UK who has status. Some people may have moved away, but want to keep their status, particularly if you have settled status. You can go and live away from the UK, and you shouldn't lose that status, but you have to adhere to a certain criteria in terms of making sure you do return periodically. So the important thing for pre-settled status holders is that you don't have as much flexibility with being outside the UK as someone who has been granted settled status, because when you're granted settled status, effectively you can have 5 years away from the UK before you would lose your status. And even if you return within that 5 years for a short period of time, so even just to take a short visit back to the UK, if it's within the 5 years, then you keep your settled status, and so effectively you can live outside the UK, but you can still keep your settled status. But one thing to be aware of, because this is something that does come up, and I have been asked about this recently, is, well, is it 5 years from when I'm granted settled status, or is it something else? And the answer is it's 5 years from when you leave the UK. So if you left the UK and you were granted settled status after you left the UK, you should not count those 5 years from when you were granted settled status. You should count it from when you left the UK. And that's really important, because if you count it, if you're outside the UK when you're granted settled status and then you start counting 5 years, you will go over the 5 years that you're allowed, and you will actually lose your settled status. So that's one thing to be aware of with settled status grants. If you have pre-settled status, as I say, you're much more restricted in how much time you can spend outside the UK. So really, you're not able to live outside the UK until you have been granted settled status. How long you're allowed outside the UK is quite a complex question in some cases with pre-settled status. So if you're not sure about how long you can live outside the UK now with pre-settled status and what your situation is, it's always advisable to talk to a lawyer, someone who understands the settlement scheme, so they can talk you through, this is when you can get settled status, and then when you get that, you can have a longer absence. So just to be clear about that situation for people who might want to spend time outside the UK, particularly if you have pre-settled status, because it's much more important that you know what your situation is and how you can qualify for settled status. Once you've got settled status, you have a much greater sense of freedom in terms of how long you can live outside the UK. And the last important thing to talk when we're talking about travel rights for people with status under the EU settlement scheme is about using a national identity card. As I referred to it in terms of updating the UKVI account with travel documents, which can include a national ID card. And it's important that you're aware of your rights, because it is a particular right that is protected by the withdrawal agreement. I've set it out on the next slide, which we can jump to, hopefully. Yeah, here we are. So the reason why this is an important right and it's a protected right is because after the UK left the EU, a policy decision from the Home Office was to not allow EU nationals to use a national ID card to travel to the UK. That's something the UK essentially wants people to use passports to travel to the UK. They think that passports are more secure than national identity cards, and that's the policy it was implemented following Brexit. However, for people under the settlement scheme with pre-settled and settled status, as I've said, it's a protected category because you're under the withdrawal agreement, and one of the conditions of the withdrawal agreement is that you're entitled to continue using your national identity card for the purposes of travel, and that's why you can link your national ID card to your UKVI account so that you can use it to travel, and when you get to the UK border you can use it to cross the UK border, and it's an acceptable document. If you were an EU national without pre-settled or settled status and you came to the UK border, if you got here with a national ID card, you are potentially going to be refused entry because it's not a permissible document for you to enter the UK with. But the one thing that we need to be clear about and to make people aware of is that even though it's within the withdrawal agreement that national ID cards are acceptable, there is a clause within the withdrawal agreement that says after the end of 2025, it is permissible for the UK government to insist that the national ID card being used by pre-settled and settled status holders is a biometric document. So rather than like some national ID cards are just paper documents. So what this clause says is that the UK can insist that people who want to use a national ID card and they have pre-settled or settled status obtain a biometric card, so one with a chip in it, basically, so like it has more security features. So that's something that's written into the withdrawal agreement. At the moment, the UK government has not made a decision about whether they will insist that people need to get a biometric card. So at the moment, there is no change that is scheduled to happen at the end of 2025, whereby only biometric cards can be used from 2026 onwards. That was something that could have happened, but the UK has not yet said this is going to be our policy moving forwards. So at the moment, you can still continue to use a non-biometric national ID card if you have one, but in the future, you may need to get a biometric card. If you already have a biometric national ID card, and many people do, you know that that's going to be acceptable. The withdrawal agreement says it has to be acceptable. It can't be phased out at any stage. It's only people without biometric cards who could be affected in the future. So if there is a policy change on the using non-biometric national ID cards, the EU delegation will use our communications channel to make people aware of the change. You can follow changes on the gov.uk pages because the government publishes their policy on those pages. So if they change it, they will be updated. So we will do as much as we can to make people aware of any changes. But if you have the option of swapping a non-biometric, like a paper national ID card, for a biometric one, it's not the worst idea to do that, because you know that you'll be able to use that. Even if the government changes its policy on paper national ID cards, it will still accept any cards that are biometric. So that's just a policy that we want people to be aware of, because it could change at some point next year, but we would hope that there'll be plenty of notice so we can spread the word for people. But last bullet point is still the same message. Keep your UKVI account up to date with your national ID card. If it changes, if you get a new one, if you get a biometric one, add it to your account, because that's the key to having a nice, smooth travel experience, is having your travel document, your national ID card, your passport linked to your account. Okay, that covers national ID cards. So the last thing that we are going to cover in the presentation is to do with certificates of application. Now, these are the document that is given to persons who are applying to the EU settlement scheme for the first time, or who don't yet have status under the scheme. So if you already have pre-settled status and you're applying to move to settled status, then you will not get a certificate of application because you already have pre-settled status. So you don't need a certificate of application. The certificate of application is for people who haven't yet got status but have made an application that is still with the Home Office, or perhaps it is not been successful with the Home Office, but it is now being reviewed, either in an administrative review or with an appeal to the Immigration Tribunal. So if you are in that situation, you will have been given a certificate of application. You'll know that you have it. It's a PDF thing, but also you'll have a digital account that you can access, and it shows that you have a certificate of application status, that you haven't yet had the final decision on your settlement scheme application. Now, certificates of application are really important because they're your protection whilst the Home Office is dealing with your case, or where the appeal courts are looking into whether you should be granted status. It's your rights are protected by the certificate of application. That means things like your right to work, the right to rent. If you live in England and you have to prove your right to rent, if you're accessing the NHS and you need to show you're exempt from NHS charges, that's what your certificate of application does. So that's when you're here. But also, the certificate of application can be used to travel in and out of the UK. However, there is quite a complex policy behind using certificates of application to travel. Particularly because when you get to the UK border, you might be asked for evidence that you were living here by the end of 2020, which is really the reason you'd be asked for that is essentially to show that you should qualify for pre-settled or settled status once your application is decided. So the UK's border policy is to ask you for this evidence, and so it can be quite a complex process to travel with a certificate of application. And unfortunately, many people, because of this complex process, just choose not to travel because they don't want to risk having issues at the UK border. And there have been cases where people have issues at the UK border, and it gets very, very complicated if you're applying as a sponsored family member, because the Home Office policy on using a certificate of application is even more complex in this scenario. It revolves around whether you've been granted an EU settlement scheme family permit, and potentially whether that has expired, because that can cause you problems with the airline if you're trying to travel. And so family members, we always say, take legal advice before traveling, because you need to know that you'll be readmitted to the UK. But also, even European citizens with certificates of application, they might want to take legal advice as well about traveling, because it can be problematic. It's something that we were aware of as a problem, and because the Home Office is going to introduce ETA, electronic travel, because they have introduced ETA, and will be doing further enforcement of electronic travel authorization next year, it could cause more of a problem for people using a certificate of application, because airlines won't be able to recognize the certificate of application as a document that allows people to travel, or that at the moment that's what the policy appears to be. And so it's going to add an extra layer of complication to traveling with a certificate of application. So if we just dive to the last slide, I've just put some information about the policy that the Home Office currently implements, which is they say that carriers, airlines, Eurostar, ferries shouldn't stop people with a certificate of application traveling just because they don't have an ETA. Because the person won't be eligible for an ETA because they're not visiting there. These are people usually who live in the UK. You have a certificate of application because you live in the UK, so you can't have an ETA as a visitor. And so, but airlines and the carriers are told to allow people to travel. But we do know that it can cause a problem. And in fact, the organisation, the 3 Million, who advocates on behalf of EU citizens and families living in the UK, they have a tool that people can report issues with certificates of application if you go to the 3 Million website, and particularly because they're looking to potentially to bring some legal action on the use of certificates of application. So if you do have issues with that, then it's something that you can report to the organisation. You can report it to the Independent Monitoring Authority, who also are the independent organisation who protects EU citizens and family members' rights in the UK under the withdrawal agreement. So they are interested in these issues as well, because it is a problem and it's an ongoing issue that we're aware of, and it is something that unfortunately is very complicated. But we wanted to cover it in the presentation just so people are aware of this issue if you haven't yet had a final decision on your settlement scheme application and you're still using your certificate of application. Okay, that's the kind of areas of travel that we wanted to cover this evening. So thanks for listening to the presentation. If there is anything, any questions that you have about that or about anything else to do with the settlement scheme or to do with sort of Brexit rights, then we'll move to that now. We'll just see if any. Yeah, we've had a few questions that have been sent in. So let me just work through these. Okay, so the first question is actually on that last topic of certificates of application, and specifically for non-European family members of EU citizens, can they travel with a certificate of application? There isn't a yes or no answer to this question. As I was saying in the presentation, it is really complicated. There are a lot of different things, a lot of different factors that will affect this. It depends what nationality the family member is. It depends on whether they previously held or have been granted an EUSS, an EU settlement scheme family permit before they applied and got a certificate of application. It may depend on whether they have a residence card that was issued under free movement law before they applied to the settlement scheme. So there's lots of different factors. There isn't a right or wrong answer. The broad answer I would give is usually not. It's very difficult for a family member to travel on a certificate of application, but there are some situations where it may be possible. But absolutely, if you are a family member, you're non-European, you're a sponsored family member under the scheme, you have your certificate of application. If you're thinking about traveling outside the UK, please take legal advice before you do so, because if you are not able to return and re-enter, then you of course will be stuck outside the UK until your application is resolved, and in some cases that can take some time. So we don't want people to get stuck outside the UK. So just please take legal advice, because the policy is very complicated in this area. It's not something we can go through the whole policy, because it would take another hour to do so, and even then there'd still be questions, and so you just need to have that individual legal advice based on your own circumstances. Okay, so we have a question about national ID cards, which is essentially, can ID cards be added to the account, the UKVI account? I assume that means after the 31st of December 2025, and they've said in brackets if electronic. So if it's an electronic, I think that means biometric national ID cards. So the answer is yes. So national ID cards you can still, what the withdrawal agreement protects is your rights. All the rights under the withdrawal agreement are lifetime rights, as long as you sort of continue to meet the conditions. And so when you have pre-settled or settled status, you are acknowledged as someone with withdrawal agreement rights. And that means if you have that status for the purposes of using a national ID card, you have the right for that for life, as long as you hold your settlement scheme status to use your national ID card. And so if you need to be able to attach it to your UK visa and immigration account, otherwise you won't be able to exercise that right. So you will always be able to attach a biometric national ID card to your UKVI account, because biometric national ID cards are always going to be acceptable under the withdrawal agreement. So after the end of this year, you will still be able to attach your biometric biometric national identity card to a UKVI account, and every time you change it, you'll be able to add the new one. What may change in 2026 is the non-biometric national ID cards. It may be that the Home Office says, no, we won't allow people to use these anymore, because that's what the withdrawal agreement permits. It permits us to say that we're not going to accept them anymore. And if that's the case, then they will stop allowing people to upload non-biometric national ID cards to the UKVI account, because they will no longer be an acceptable travel document. But if that change in policy happens, then we will be informed about it. We will in turn do our best to communicate that to people, to make sure that you are aware of that change. But at the moment, you will be able to update your UK visa and immigration account with new national ID cards when they are given to you. Okay. We've had a question about the settled status and the 5-year absence rule, and hopefully it's one that I think it might have been a question that was posted before I touched upon it, but it's always useful to repeat these slightly more complicated questions, which is, when you're looking at the 5-year absence rule for settled status, does that mean 5 years from when the settled status is granted, or from a date of absence which is prior to the settled status being awarded? So the first thing to say, this only matters if you are granted settled status when you are not in the UK. If you are in the UK and you are granted settled status and then you leave the UK, obviously you'll be leaving the UK after the grant of settled status, and so your 5 years will be counted from when you leave the UK, because your grant of status came before you left. But for people who are outside the UK and then they're granted settled status, and this happens to some people because you can get granted settled status based on a historical residence period. So let me give an example. So if you lived in the UK between 2015 and 2020, and then you left the UK in 2020 to go and live somewhere else, you may still be eligible to be granted settled status, because you have a 5-year period of residence, and that's what you need for settled status. And then as long as you never were absent for more than 5 years after you left the UK, then you would be eligible for settled status. So if you had, let's say you left in 2020, but you came back for a visit in 2021, and then you left again in 2021, and you applied and were granted settled status in 2023, that's okay, because your 5 years was between 2015 and 2020. You didn't have an absence of more than 5 years from the UK, because when you applied in 2023, that's not 5 years after you left, so you qualified. But what you have to bear in mind when you're granted settled status and you're overseas is that 5-year clock is already running. So that 5 years that you're allowed outside the UK before you lose settled status is already running. And so if you were outside the UK for 2 years and that's when you were granted settled status, you've only got another 3 years before you would lose it, because you would lose the settled status at 5 years of absence from whenever the last time you entered the UK was. So that's something to bear in mind. So if you were granted settled status and you were outside the UK, do not use the date you were granted settled status to calculate the 5 years. Use the date you last left, and all you need to do is return for a short period of time within the 5 years, and you will reset that 5-year clock. And keep the evidence that you visited the UK or you travelled here, because you might one day be asked to show it. So do keep a record of the travel. Keep a record of, like, if you spent some money whilst you were here, if you had to book some accommodation, then keep a record of it, because you might be necessary to show that in the future. But that's the point, is once you've got settled status, you can live overseas, but you have to enter at least once every 5 years to reset your clock. And the 5 years is calculated every time from when you last left, and that includes even situations when you're granted settled status overseas. Okay, so hopefully that's clarified that one. It is a slightly confusing situation. I do appreciate that. It's not always straightforward. We try to there's a website that we run called EU Citizens UK. We can put the link to that in the chat. It has information about these questions. It has information about that 5-year absence that settled status holders have. It has information about how much time you can have outside the UK when you're a pre-settled status holder and you want to move to settled status. We've tried to give detailed information about these questions because we know that they're not straightforward, and we know that they come up and we get asked them. So we want, here you go and have a look at this information. Hopefully it answers your questions. So that's a really important resource that we hope helps people. Those are the questions that I've had come in. So unless I get any more fired across to me in the next couple of minutes, then I'll look to wrap up the session this evening. Just to say, and whilst we're waiting just for those last possible questions, we want to make sure that people get good advice. If you do need to speak to a lawyer, and people do, in some situations it's not always straightforward. The settlement scheme is not straightforward. The rights under the settlement scheme can be complex for people. So you may need to speak to an advisor. If you're speaking to an advisor, make sure that you speak to someone who's regulated, who's qualified and is regulated by a professional body to give you that advice, because they're the only people who you can make sure actually know what they're talking about, and they have a professional body that they have to have standards. If you speak to someone who's unregulated, there is no one who can make sure that their advice is correct, and usually it's a criminal offence to give unregulated immigration advice in this country. And so make sure you speak to someone who knows what they're talking about, because it's complex and you want the right advice. It's important to you to get the right advice. So we just want to be clear about that. We have had another question. Exciting. And so we'll just deal with that in the time we have left. So I'm just going to read this out, which says, if someone's pre-settled status has lapsed due to breaching the absence rules, is the person still allowed into the UK? And if they are, at which point would they not be allowed entry to the UK? Lapsed status is one of the most complex issues that arises under the settlement scheme. So it's a very good question that's been asked, but a very difficult one to answer. To explain, because most people wouldn't necessarily understand what lapsed status is. So this is where someone is away from the UK and their pre-settled status, or their settled status in some cases, will automatically expire effectively, or it's automatically taken away. So I was talking about the 5-year allowance that you have of settled status. So if you are away for 5 years with settled status, then the UK law says, well, you've lost that status because you were away for too long. You were allowed up to 5 years, and all you had to do was come back within those 5 years to reset the clock, but you didn't do that. So now you've lost your status. And that can happen with pre-settled status as well. The situation for pre-settled status is even more complex. And obviously once you've lost your status, you no longer have, it's your resident status, it's your right to live in the UK. So it's also your right to enter the UK, as we've been talking about this evening. So if someone does lose their status because of the lapsing status rules. If you then travel to the UK, you are essentially traveling without a permission, without the right status. And so if this is picked up on, it can result in people being refused entry. Now, the reason why it's not always something that's picked up on is because entry and exit data is not always accurate. And so it's not necessarily something that's going to be spotted by border officers or any other systems, because it's not necessarily clear whether someone has been absent for too long and their status has lapsed. So in terms of like at which point would someone not be a permitted entry if their status had expired? So if your settled status had expired because you were away for the UK for more than 5 years, and let's say you tried to come back after 7 years, and would it be established that your settled status had lapsed? I don't know is the answer. It might be, but the entry and exit data is a complex set of data, and it wouldn't necessarily automatically understand that someone has not been back within the 5 years that they're allowed a settled status, and so they might just be able to carry on. But the important point would be that their status has gone. And so at some point it might be established that they no longer have status. So it is a really complex area of law. The interaction between lapsing status and the withdrawal agreement is also extremely complicated. If you have questions about that, if you're worried about lapsing leave, if you're worried about whether it means you have lost your status under the settlement scheme, it's worth speaking to a qualified and regulated advisor, because sometimes there are ways to get a different grant of status, even if your status has lapsed, and sometimes there might be things that can be done in the context of pre-settled status, because people still want to move to settled status. So it's worth speaking to a qualified advisor if you have a lapsed status situation. But it is complex. So again, it's not, I mean, we could do 2 hours on it this evening, but it would probably, people have got better things to do, I'm sure, and we're coming to the end of our time. So it's a good question, but it is a really complex situation. Okay. That has now taken us nearly to past. So in the end, the questions, which were very good ones, we were able to address some of those complex issues. We will do another session in December before we all have a break for the festive period. I think we're looking at probably doing having a little review of what's happened in 2025, and then looking forward to 2026 and some of the policy changes. Sorry, that isn't. We had the wrong date for the next session on there. I'm sorry. That's why. But we will do it in December. We will post about the session in December once we have confirmed the date. I'm just going to check if I have the date to give to people. It will be most probably Wednesday, the 17th of December, same time as this one. We will post about it in advance just to give a kind of little summary of what we're going to talk about. If people do have questions or issues that they would like covered, please feel free to get in touch. We always want to take those into account. As I say, we have in mind that we'll look at a sort of a bit of a retrospective and a little look forward to the next year ahead to see what important things might be coming then to kind of get us in the mood to move into 2026. But we're also very happy to take suggestions on board. So please do join us, and we will confirm that it will be on the 17th, but that's the most likely date. And until then, I hope everyone has a wonderful evening, and we look forward to seeing you soon. Thanks for joining.